Welcome to the Kentucky Auto Accident Podcast. Louisville attorney Jim Desmond has been handling injury cases related to traffic accidents for over 20 years. Jim will provide valuable information to help you and your family. He wants you to understand the important issues you need to know when it comes to handling car accidents and motorcycle wrecks in Kentucky. There's a lot riding on this, so let's get started. Friends, welcome to episode 10. We're going to rejoin Jim Desmond as he continues the discussion from episode 9 related to motorcycle accidents, what happens once you've been to the hospital, ensuring that you have the treatment that you deserve, and at the same time, what happens if a lawsuit ultimately has to be filed on your behalf.
One time, I successfully argued that their contract language was lousy and they had no right to recover anything, okay? In that case, their contract language did allow them to take a future credit against future medical bills. So instead of us paying them, I think it was $4,000 or $5,000 out of the settlement, they were able to say they weren't going to cover the future medical bills for $4,000 or $5,000 worth. In that scenario, my client had other means, so he wasn't worried about it. It was still preferred that way. But again, that's why you can't just ignore a health insurance lien and say, oh, my attorney's not working for me or something because they're making me pay back Medicaid. No, they're doing it to protect you so you continue your health insurance coverage and so people won't get sued down the road when we get this case all done.
So we've talked about, again, PIP coverage, having the right coverage up front. We've talked about things that you need to do right there at the accident scene, if at all possible, if it could be done safely. And that would obviously include witness names, witness statements, things like that, getting all that, getting the police report, and we'll put that link to buycrash.com in the show notes. Now we're at the hospital, and you've ideally made them aware that, okay, yeah, this is an automobile accident, a motorcycle accident, so they kind of know how all that's going to flow through. What are some of the next steps that a injured motorcyclist needs to be concerned with?
Well, and let me go back to one exception. Remind me of your question in 2 seconds. Well, no, let's go to your question first. Okay, what's the next steps when you're at the hospital? I want them to be able to get the treatment they need. Okay, so that first step is hopefully they have health insurance coverage. Yeah. If they don't, I'm going to tell them usually to go ahead and talk to the financial counselors at the hospital. And most of the hospitals have a financial counselor, and they can try to get them to qualify for Medicaid or whatever it might be down the road. And how does that serve us? Twofold. One, they can get the treatment they need because they now have health insurance. Okay, and two, it will reduce the medical bills. And remember something on that. When I say they can get the treatment they need, the at-fault carrier, the liability carrier, remember something we said in the previous podcast, they're not going to pay the claim as it goes along. They will pay one time and they will pay in a settlement. They don't want to pay for every doctor visit because they want to preserve the ability to argue, okay, these doctor visits aren't related or the surgery's not related, all right? So that's why it's crucially important to use the Medicaid, if you can get it. Or if you have private health insurance, fantastic, all the better. But in a motorcycle wreck, definitely we're going to use the health insurance. In a car wreck, we may use the no-fault insurance or we may reserve it. It just depends either way.
Depends on the scenario, depends on the client's scenario or situation. A lot of other factors that kind of come into play.
My next step after I leave the hospital is to request the emergency room records and bills, as well as the EMS, okay? Because I want to get an idea how much the first bills and such are. Second step is I got to get the insurance claim open on both sides because, again, I want to see how much liability insurance is on this other driver. I want to see how much uninsured coverage is, or uninsured or underinsured is on the motorcycle, or, could I get an automobile policy to apply? Because, again, on a motorcycle, accident, I'm looking for a worst case scenario. I'm trying to get ready for the possibility that all of a sudden we're going to get hit with something. I was trying to think. I got a bill the other day from a hospital that it was a day and a half of hospitalization, and it was $23,000 right off the bat.
Wow.
Okay, so the helicopters. God forbid anybody gets flown.
So a life flight type.
Yes. They're tending. They used to be $35,000. They're up to about $50,000, I think now.
Wow.
Okay,
and that's charged back to the injured victim.
So again, you got to have to either try to get it down through some means, whether it's negotiation, health insurance, or something else, or reduction. But yeah, you've got to get it down because again, it's too much.
And as you said from the outset, these injuries that happen, these collisions that happen with motorcyclists, are going to be more catastrophic. They're going to be more serious in nature, typically. Especially if this is on a highway or some other area. So there's a chance that a life flight may actually be involved.
Right. I mean, the damages in general, that's the thing that, if we get hit in the rear end, all right, and we're what we call a soft tissue injury, all right, with no broken bones or blood, and I'm talking about a car wreck, okay? it's a cervical, cervical and a lumbar strain. I get it. That's a severe injury as itself, and it can be, and it can hurt a lot. But it's not like a motorcycle accident where so much, I mean, if you think about your damages, you not only have your past medical bills, you have your lost wages because chances are you're not working, okay? You have scarring because chances are your skin basically got torn apart on the pavement and such like that, okay? There's all these things. And then everything goes into the future. What is, when can you go back to work? Can you do your same job? Well, did you have a leg injury that doesn't let you stand for 8 hours anymore, okay? And again, how do you protect yourself? It's that uninsured and underinsured because what I always try to tell people, and I hope this, Jim always tells me this podcast, make sure you guys can see something in your head. Well, what you need to understand is if you lose your left arm in a car wreck and you're hit by a semi-tractor trailer, we're fine. All this stuff is kind of academic discussions, and we'll, ultimately there's more than enough insurance coverage to cover everything. We'll figure it out. If in the same case, though, you lose your left arm and you're hit by a 1980 Yugo, we're in trouble. Because if you're driving a 1980 Yugo, you don't have $1 million in the bank, and you don't have a whole lot of assets that we can go try to collect a judgment against.
And ultimately, a lot of these settlements, a lot of these situations come down to what's the insurance available.
Correct. And that's the part that is so unfair about Kentucky law, is that there's no guarantee in the law, and I know I remember saying this specifically, almost verbatim, there's no guarantee in Kentucky law that the other driver has enough insurance to cover your medical bills, damages, or future treatment. And the only way you protect yourself is this other insurance. And then the reason I say in the beginning that the motorcycle accidents are like a law school exam, because that's what tests it to the limit. Because you've got to use everything from the health insurance to the dealing with the lack of PIP to the uninsured and, the liability coverage. It all comes into play on a motorcycle accident, and that's assuming you can show fault. I mean, that's one of the reasons we talk about what can you do at the scene, because you got to be able to show fault in that other person. If you're a motorcycle accident and you cause the wreck, you're out of luck in a whole lot of ways, but that's another story. So,
well, I tell you what, let's use some of the remaining time here to talk about a lawsuit.
Okay.
Let's say, obviously you've been going back and forth. You've got an immense amount of communication with the other insurance companies, trying to get this thing settled, trying to get a fair settlement for your client, and it just doesn't move the way it needs to move. What happens now? Okay.
Well, and let's go specific to motorcycle accidents for a second. I would honestly say 80% of the motorcycle wrecks settle before a lawsuit, and I'll tell you why. And this is the tragic part again, is because the damages far exceed the insurance coverage, okay? But the thing about in a lawsuit, everybody wants to say, oh, I'm just going to sue this person. I'm just going to sue them. What they need to understand is it's not that easy. First step to filing a lawsuit is you basically file what we call a complaint, all right? You go down to the circuit court clerk's office, you file a complaint, costs about $300 and some odd, all right? Well, for you as a consumer, you need to realize two things. One, that $300 and any other expenses come out of your personal injury settlement at the end. And two, most attorneys have a provision in their contract that if a lawsuit's filed, their fee jumps up to a higher percentage. Okay,
it's going to take a lot more work for them to get all the documents, get all the expert testimony. There's a lot more that goes into taking a case to trial versus trying to achieve a successful negotiated settlement.
Right. And that's the thing that you got to look at. Is the case worth it? Because again, and I do this with clients all the time, if I have, I think we talked about this on a prior podcast, if you have a $12,000 settlement offer and you think you want $20,000, well, chances are if you look at the higher expenses and everything else, it's not going to be worth the risk. Okay. So again, I would say most of my cases end up in a lawsuit are ones where the insurance company forces my hand. Ridiculously low offers, not considering things, that type of stuff. But once you file that complaint, they also have 20 days from the time that person, that other driver, is served with the complaint to file what we call a written answer, okay? And what's going to happen is that person is going to put their insurance company on notice, all right? And they're going to hire a defense firm in town to defend that lawsuit. Now,
the insurance company is.
Yes. Yeah. Because think about it. The insurance company for that at-fault driver has a duty to defend and indemnify him, okay, from the lawsuit. That's what he's paying for his insurance, right? So one of the problems, again, if you ever drive a car that's uninsured or even a motorcycle, what's one of your problems right off the bat if you get sued is you go to an attorney and say, hey, I got sued and I want to file an answer because I want to try to stall this thing. You're talking to file an answer, depending on an attorney in town, probably at least $500 to $1,000. Okay.
Yeah.
So it's a situation where it goes from there. But so they take their time, they file an answer. At that time, we're going to send discovery requests to both of us. Okay. We're going to send 30 questions called interrogatories and request production documents to them, and they're going to send it to us. And what people need to understand about discovery is there's nothing Perry Mason-like when you go to trial. You have had plenty of time to go through everything, and you know every answer that's going to happen before then. So that's why we have discovery requests. So it says questions that will go back and say, for my clients, it'll go back and say, list your past medical history for the last 10 years, every doctor you've ever gone to. And people are like, well, why do I have to do that? It's not relevant. It is, because if you're complaining about a back injury and they can go back and say 4 years from, before this wreck, you were still complaining about a similar back injury, they get to be able to look at that, possibly argue that to a jury. Okay.
Right. So the pain you're experiencing right now in your back may not be 100% related to the accident you just had. This is a pre-existing.
That's what a defense counsel wants to argue. Because, and think about why would they want to do that? Because it's worth less. Yeah, it's worth less. So, because they want to, the job, we always say that the plaintiffs have the hardest job because we always have to show to a jury 2 + 2 = 4. All a defense counsel has to show is that, 2 + 2 doesn't equal 4. Okay. So if they can just poke a little bit of holes here and there in your theory, you're in trouble already. Right. Okay. So you answer the discovery request. You both have 30 days on average to do that. Most of the time those get extended. You'll do that as a courtesy on both sides. At that point, you'll take, once those are done, you'll schedule depositions. Well, unfortunately, between all calendars, again, you're probably talking 60 days, 90 days out from there. Your deposition is taken. Well, your deposition is anywhere from an hour to 2.5 hour sworn statement with, I would be there, the defense counsel would be there asking you questions, and a court reporter. And they're going to take down everything under the sun. They want to pin you down before you ever get in front of a jury to say, okay, the light was red when you entered the intersection, or that you were 15 feet out when you saw the car, whatever it might be. They want to pin you down, okay, on your story. And that's why they're doing that. At that point, once that's done, then the next step is a possible mediation. A mediation is a settlement conference, okay? And mediation is a great thing. Anybody, if you're in a case right now with another attorney and you have a possibility to mediate a case, take it.
You retain the most control you're going to have over this thing as long as you're in mediation, because at least at that point, a judge isn't coming in and making an arbitrary decision.
Well, and
the jury's not coming in and making.
The jury more correctly, yeah. And you're jumping ahead, but I'm going to say something what you just said, Jim, which is true. This is what people need to understand, because the press likes covering the stories that sound big, the coffee cup case and all this other stuff. Yeah, all right,
McDonald's case, yeah.
But the thing that you need, once you really get in front of a jury, you realize that you're rolling the dice, okay? It is literally like going to the casino, okay? And it's not as bad as the casino, but, I've been in a lot of different positions when in front of a jury before, and you hear the questions come back, and they're nothing we ever expect them to say or ask. And they can award different amounts. Now, should you do that? Is it worth the risk? That depends upon the insurance company. That depends upon the current offer and what your attorney's telling you. Because again, remember something about lawsuits. And people always say, well, so-and-so got this or so-and-so got that. Well, that's never a fair comparison, because lawsuits are fact specific. I want to say that a couple times, even though I didn't do a good job with it. Meaning, okay, it depends. If I have the same injuries and my client was hit by a nice little old lady on the way to church, I'm not going to get as much on that case as I am if it was at 2 a.m. and the guy was drunk and came out of a bar.
Right.
Okay.
Right.
So it's very fact specific. And so it's one of those that is a roll of a dice. So go back to mediation. A mediation is a settlement conference, and it's not binding. Okay. Arbitrations are binding. Mediations are not. Okay. Typically what will happen in mediation is 9 out of 10 times it'll either be a very experienced attorney or a retired judge, and you'll go in a conference room and your attorney will be there. The other person's attorney will be there, maybe an insurance adjuster. And you start with usually 10 or 20 minutes on each side saying, this is what my case is about. This is my client's injuries. And then he says, this is why we don't like the case and such. And then you split up. And then they separate you into different rooms. And at that point, you start this back and forth process where you say, well, we're demanding $50,000. And they say, so the judge comes in and says to us privately, well, you're too high. Why don't you, let's go back and try for $45,000. And he goes and talks to them and says, no, you guys are too low. You guys should be offering, you're only willing to offer 10. Well, let's get that up to 15. And you see if you can hit a middle point.
And if I could interject here, usually this mediator has some experience with these types of cases.
Oh, absolutely.
I mean, this judge has seen these types of this retired judge who's probably your mediator has seen these kind of cases. So he or she has a good feel for, well, this kind of case probably is worth a little bit more here or a little bit less there. And so when they're saying, no, you're high and they're low, it's based on some experience. I mean, there's a point of reference here.
Yes, and they justify it. And don't get me wrong, Louisville probably has, I mean, we have really good mediators. Louisville, Southern Indiana, I'm not going to say names on this, but I'm thinking of people right off the bat that, I mean, we've got some really good mediators. And that they are good because, again, I mean, you got to realize, I always like what one mediator starts with. One time he's a retired judge. I should give him credit for this. But he says, nobody's going to walk out of here feeling like they won, because if we feel like we won, then the insurance company's not going to offer that amount. If they feel like they won, then we're not going to take it. Okay. So it's a give and take, and it's going to, it's trying to get a win-win scenario. But if you can get it settled, fantastic. Then all of a sudden you're avoiding that risk and everything down the road. But understand something. The process we've talked about, this is where I want people to understand lawsuits, because they're not easy. You're talking, the process I just mentioned to you, on average, 6 months from the time you filed the complaint, maybe up to a year.
And this is from the time you filed your complaint, not from the time of the accident.
Correct.
I mean, so this is really extending the life of this situation, trying to get to resolution for something that probably wasn't your fault. I mean, that's why it's a big deal.
Right. And I'm glad you said something about the time of the accident. Oh, we got to go back. All right. Statute of limitations for motorcycle accidents. Everybody remembers statute of limitations means you have a certain amount of time to file a lawsuit in Kentucky, or it's barred like it never existed. In Kentucky, a car wreck is 2 years from the date of the car accident, or 2 years from the date of the last no-fault payment. I encourage my clients to forget about the second no-fault payment and treat it promptly and talk to an attorney before the first 2 years. But the point is, you have the ability to extend it with a car accident because you've got no-fault or PIP payments, right?
Right.
Motorcycles, you don't have no-fault or PIP payments, so you can't extend it. So you have a 2-year statute of limitations with a motorcycle accident. So immediately, you really want to be smart and safe and say, okay, let's say you don't want to hire an attorney for personal or for a motorcycle wreck, which I think is a mistake. That's another issue. Ask me in a second why that is a mistake. I'll tell you. Back it up. 18 months from the time of that motorcycle accident, you should either have that case settled or be preparing it for a lawsuit with an attorney. Okay, because you should not come to an attorney at the last minute with the statute of limitations. And by the way, to stress something on that, I don't do legal malpractice. Somebody called me the other day, and I don't do that. But the reason we won't touch a case too close to the statute of limitations is it's an absolute, okay? So it doesn't matter that you lost your left arm in the wreck. If you file 1 day late, we malpractice the case, okay? And then you have a claim potentially against us as well. I just told you to come back to,
you were talking about why you need an attorney, especially with a motorcycle accident.
Yeah, that's the other thing I wanted to hit on. And I know I just jumped around on you guys, so sorry about this, but policy limits on a motorcycle, be careful, okay? Because you're going to think you're saving and you're not necessarily doing it the right way. If you hear policy limits are generally $25,000, $50,000, $100,000, $250,000, or $300,000, and those are the general ones you hear. Okay, they're not. You don't see 75 in Kentucky. You don't see 110, nothing like that.
And again, these are the face value of the policy.
The maximum amount, right, on insurance. All right. Well, remember something, especially about a motorcycle accident. And there's a policy, there's a procedure you have to follow. If you really want to Google it, look up COOTS. We've talked about before, COOTS procedure, or the statutes KRS 3. I don't want to get this wrong. KRS 304.39-320. It should be.
I'm going to stick with BR 549.
Now
that's a reach back. Sorry, go ahead. So you're talking as we go here.
Yeah, he just confused me two people
about COOTS and things like that. All
right, but the point being, if you have a liability carrier on a motorcycle accident offering you a policy limits without an attorney, realize you might have an underinsured claim. And if you don't take the procedure outlined in, according to Coots or that statute, the same thing, okay, which really only attorneys usually know how to do, but that's another story. Then you're walking away from your underinsured claim. And again, an insurance adjuster's job is not to advise you as to what the law is. An insurance adjuster's job is to basically get that claim settled. So again, if you try to avoid, and some people can, and I'm not saying you can't, but be real careful. If you're going to try to handle a motorcycle accident by yourself, two huge pitfalls, from this podcast you can take away is, one, you've got to deal with the health insurance lien, and you can't ignore that. And two, is it a policy limits case where I potentially have underinsured coverage to go against? And we've got to know those two things. Now sorry to do this to you, but I'm going to jump back to litigation for one more second.
Well, we've still got a few more steps here in the litigation process. Right. So we've been in mediation. Ideally, we've reached a settlement, but sometimes it just doesn't come together.
Right. And that's the part that, again, you got to watch and you got to see, because, okay, if you're going to go to a trial, okay, you're taking a big gamble, that's fine. It might be worth it. But the part that I want people to understand is, okay, if the mediation fails, now you're starting to go back and take the depositions of your doctors, okay, the other experts involved, all right? So all your expenses are going up. That's the part I want people to understand, is that you go to trial and you recover $100,000. Well, you've got a 40% attorney's fee, so you're already down to $60,000, okay? And your expenses might be, in that case, let's say another $10,000, you're at $50,000, and you got a health insurance lien that's $7,000 or $8,000, you're at $43,000 out of $100,000. So can a case be worth it to do that? Sure, it depends. It depends upon the case. It depends upon the risk. It depends upon what the people are offering. And that's where I say, if you're at that point, you sit down and you trust a good personal injury attorney and attorney that hopefully is representing you by then, and see what he or she recommends. But I do want people to understand it's not as easy as, I'm going to go to trial and I'm going to get $100,000. We are, and again, I'm going to stay away from politics mostly, but we are in a very conservative era right now where people don't want to award money for car wrecks. And the other thing that I don't know if the average consumer realizes is a jury never hears the word insurance, not once. Okay.
And I still find that amazing. I mean, just after all the podcasts we've done and other times this has come up, you guys don't mention, and you're actually
we're not allowed to mention insurance. It's considered prejudicial to the defendant. Okay. So the short story on it is, this is the problem you have, is you have a case would be, Smith versus Johnson, and a jury's sitting there saying, okay, well, we feel for Mr. Smith real badly because he was hurt badly in this car wreck, but we don't want Mr. Johnson to be such that he's having to pay a judgment the rest of his life, and he might have $20 to his name. So there's all these little nuances, and that's why, again, our job as an attorney is not to tell people what to do. Okay, our job is to give you advice. Make sure you are fully informed of your decision. Okay, and then you can decide from there which way you want to go with it. Do we still have time?
Yeah, we've got a few more minutes here. I mean, as we talk about this, so you've got depositions, and so both sides are taking depositions of the experts.
Well, I was going to switch away from litigation.
Sure.
Okay, because there was one thing.
Let's finish that up real quick.
All right.
Then. So you've got the depositions, and at that point, you're setting a trial date, and it goes in front of the judge and jury, and that's where all the facts come back out, and you're pleading a case, they're pleading a case, and at some point, somebody's going to make a decision.
Right. A jury. Well, but okay, yes and no. But realize, again, you want to go through that process. First step, usually in Jefferson County, you get assigned a trial date, okay? When you get assigned that trial date, you're one of 4 cases typically on that date, okay? The theory is 2 of them will settle, 2 might be going, and that day. If both are scheduled to go, they're probably going to take the older one, so now you're going to be bumped to another date where there's going to be another 4 cases, okay? So, again, it's going to take a while, all right? Now, in addition to all that, if you go, as you were just saying, you go and get a verdict, and let's say it is favorable, okay? Understand something. If a legal issue was done wrong, okay, in other words, the defense counsel says, this was a favorable verdict in favor and for the plaintiff, but what we look at and say, the judge ruled the wrong way. He let something come in that shouldn't have come in, okay? The jury heard something they shouldn't have heard. Well, they have a right to appeal that to the Court of Appeals, Kentucky Court of Appeals. And again, that's a situation where 18 months or 2 years from then, they'll make a determination. And that could either come back and they say, yes, we're going to uphold this verdict, we're fine, or two, you could have to retry the case, whatever it might be. Now, there's a lot of little nuances to all that, where if you can get interest from that point forward and the attorney can go through it, but it's a long, lengthy process.
And let me come back to something that you mentioned in the middle of this, because we're talking about substantial time. And you said that the insurance company oftentimes is going to hold that money until they kind of get to the end because they want everything in. Is it possible that the crash victim here has still not gotten anything paid?
Sure.
And so they've got hospital bills, they've got all these other things hanging out there. They still may not have gotten back to work. All this other stuff, life is still going forward.
Right.
And you're still waiting for a court somewhere to make a final ruling here.
Mm-hmm. Absolutely. This is the problem. This is, and I know it all adds up.
And this has got to be emotional for the family. I mean, this for your clients, this has to be an emotional situation.
Well, true.
Do we go to trial or not?
Right, and that's one of those reasons why, if it's a good offer, and most of my clients trust me, but if I really feel there's a good offer and we're not getting where we need to be getting, then I'll pull the client in and we'll sit down and go through it for 30 minutes and stuff and hear each other's point of view. Because, again, if it's a good offer, you don't want to put somebody through a lot of headaches, okay? But yeah, that's back to the unfairness of the law is what you're hitting on, which is, there's nothing in the law guaranteeing the other person has anything to pay for your damages or anything else. So again, I always tell my clients, act like the accident was your fault, okay? And I don't mean that in the sense of, that to forget the liability claim, but I mean what they got to do to minimize their damages to either get back to work or, get the treatment they need, take care of themselves, do it, okay? Don't worry about the lawsuit part, okay? Because what you just described, I was thinking of one person I had who was a client, and I won't go into too much of the details. He was an employee with a good local company. The other guy that hit him had no insurance, okay? And I shouldn't say we recovered something on it. But the short story was his saving grace was that he had the health insurance, the short-term and long-term disability care through the employer. There was something else that kicked in, I'm trying to remember. But for those kind of, things that he bought ahead of time, yeah, he'd been in trouble. And that's why, Jim, you didn't realize this, but that's one reason I went back and I go back and stress this uninsured and underinsured, because we as individuals, before this podcast started, Jim and I are talking about taxes and retirement accounts and all this other fun stuff. Well, we plan for all of that, with life insurance or disability insurance and retirement accounts and contributions, all these other things. But the problem you have is you do all this planning, and then we all of a sudden get in a car wreck that wasn't our fault, and everything we planned for went out the window. Because again, I think there was an article the other day that talked about, I think 80% of us or something like that don't have, enough savings to get by 6 months.
Exactly.
Without it working. And, and that's the typical American consumer. So again, if you don't have this other kind of insurance that we still may even have to fight for people to do, this is why, this is what you need. And to go back to another point in the beginning, this is all the more reason back to play it by the rules when it comes to the insurance. We talked about exclusions in the beginning. It's not worth the risk to try to save some money and give an insurance company a possibility to say there's no insurance coverage under this contract. Because what we're just describing in litigation, you could have two lawsuits. So if you have an insurance company that says, okay, we didn't know your son was a registered a driver in the household, and he's got to be usually above 20 years old or something, but it's a long story. But as a quick example, you don't want that insurance company to say, not only do we not think the claim is not worth anything because we think he was at fault or the condition was unrelated, but also we don't think there's insurance coverage because we didn't follow this part of the policy or that part of the policy. I always tell people, when I buy a car, there's a provision in the insurance policies that it's a replacement vehicle, typically it's covered, and I don't want to give you a definite time because the policies can differ, but typically it's 14 days or beyond. But I don't take the chance. Before I get that car off the car lot, I call the car dealership. Here's my policy number. Here's the VIN number of that vehicle. Put it on there. You don't take a chance, because what we just went through in litigation, excuse my French, litigation is a royal pain in the ass. And unless it's worth it, you don't want to do it. And I'm going to make one more point on this. I got time?
Sure.
All right.
Absolutely.
One more point. Think about why it's a pain in the ass, okay? And I'm not downing defense counsel. I used to do insurance defense. But as a plaintiff's attorney, my job is to recover as much money as I can for you, okay? Preferably as quickly as possible so you can put it behind you, and especially if it's a limited pot, right? A defense counsel, they don't work on what we just described, which was called a contingency fee. They work hourly, all right? So if Ohio Casualty sends a case over to a local defense firm, they get paid by how many hours they bill out, all right? Well, there's a lot of good defense counsel, and I'm not saying they run up the bill or anything else. I'm saying they're not going to go back to Ohio Casualty until they've thoroughly investigated every damn avenue of this case, okay, to make sure their recommendation is right, that when they're saying, hey, this case is worth $15,000, that they're right, and they don't find out down the road that something could have come up. So again, it's a total different way of doing things. So when you go to file a lawsuit, it's a different process. You got an insurance adjuster there. His job, he wants to get that case settled if he can. He wants to move on to the next one. That's his job. Defense counsel, his job is to minimize basically what that insurance company has to pay out and to make sure that that insurance company is evaluating that claim based upon every single fact that they can be aware of. And what are those facts that they're looking at? Your past medical history the last 5 or 10 years. Okay? Anything you said.
Take your time coming through that stuff.
Right. Anything you said on Facebook that said otherwise, what you said at the accident scene, okay, that you were, I've seen this before, this is crazy, that you offered to just settle the case right there with the guy that hit you. That is stupid, okay? You're killing your case from minute one. Those are all things that kind of come against you. So it's just a very different way of doing things. And again, I don't know, I hope on this podcast has been clear, it's not everybody has to pursue a personal injury claim. I get that. A lot of people don't like personal injury claims. They don't like car wrecks. I understand that. But guess what? Let's make sure you know all your rights and you know all that's going on and that you're prepared for whatever you might have to do. Because, again, if you're hit by somebody and it's not your fault or they don't have enough insurance or they don't have the means of paying your medical bills or you're off work longer, you want to be prepared. And the law says you've got to know that and do that ahead of time.
Jim, I tell you what, that is a tremendous amount of information. I really appreciate it. I mean, you always show up for these things prepared. This is your craft. You know what you're doing, and it's a pleasure working with you. Look, one of the things that we try to do in each episode of this podcast is to talk about a segment called "So This Happened This Week." Earlier this week, you were talking about some unpaid bills and dealing with some people that actually just, it's, again, the value of having an attorney on your side. You want to unpack that for everybody?
Well, and even as an attorney, it drove me nuts. But the short story is I got a case settled, all right? There was no fault coverage or PIP coverage remaining, all right? Well, 6 months after the settlement, my client gets a medical bill, okay? All right, we're fine. It's one of those that neither of us knew about. So the short story is we've got PIP coverage to pay it. Well, the problem you have sometimes with these providers, and this is where I say you have to kind of continue to know what to do and harass them a little bit, is there was a collection agency. So I call the collection agency and I say, here's the no-fault carrier. Okay, bill all your stuff to them. Guess what? We can't take that information. Okay, they give me another number. You got to call these people. Call that one. We can't take that information. You got to go to this website and upload this information. And so I had to do this for this bill. Even after I did this, okay, then I get a second response from them. I get the first response says, okay, great, thanks for the information, we'll send it off. And then the second response I get is, do you have the contact information for this insurance company, which really was already in the first, email. But also I responded back kind of a smart ass. I'm like, do you understand what Google is? Okay, exactly. Because that's how we have to do things lots of times. My point being, again, for you as a consumer, know, and this is where your attorney's probably going to help you. Are we billing no-fault coverage or are we billing health insurance? Which one? Send your health insurance card or your no-fault information directly to the providers. Tell them to bill it. And then the third thing that I love, my clients are gotten really good about this, I send them self-addressed stamped envelopes, and every medical bill that comes in, they send to me. Okay, because I want a copy for that file. And so then that way, if I'm sending that health insurance and PIP information to that medical doctor saying bill it, my client's doing that, it helps a lot. Because the problem you have with the unpaid medical bills, I always say I can get a really good settlement for a client, and if there's a $50 bill, unpaid 6 months after the settlement, they still want to strangle me. Okay. Yeah. And I understand that because you think it's behind you and you get scared and you're like, if there's one, there's got to be more. So again, it's maybe the big issue for a consumer again, and this is for any personal injury attorney, they need to realize you can't just turn it all over to your attorney, that it's a collaboration. To handle a good car wreck case, effectively, it's a collaboration between the two when it comes to where you've gone for treatment, who your medical bills are, or, who's generating medical bills and who has given you that treatment. So
while you're going to let your attorney run the ball for you, keep your attorney up to date on doctor's appointments,
yes,
results of tests, communications that may come back, just so, again, you have everything in a file that's organized so that you know what to say, when to say it, and how to say it to maximize that ultimate settlement for the client.
Yeah, and I'm going to be bad on here. I'm going to be bad on badmouthing some bigger firms again. The problem with that sometimes is it's a good thing to do, but unfortunately, again, you're not giving it to your attorney. You're giving it to this case manager who's not an attorney, and I don't like that as much. But one of the things, this is why, again, I shake my head on something, okay? My law practice is going to have its 15-year anniversary this July. And from that date forward, from day one, I've used my cell phone. Well, the whole point is it's so easy to get that information. So, like what I tell my clients, I say, take a picture of the card if you want, or give me the phone number and send me a text. Save that. And guess what? When I have that in the file, if I don't know who that is, guess what I go back to? Google. Okay?
And Jim, I know you're very confident in doing this. If somebody does want to pick up the phone and give you a call or send you a text, what's the best number for them to use?
I have one number only. It's my cell phone. It's 502-609-7657, 502-609-7657. Feel free to call or text it. Once you are one of my clients, I save your number, so I'll have it down the road. And, like I said, I only do car wrecks, but I'll be happy to try to give you some advice on other stuff sometimes. People just need to understand that's, if you're asking about certain kinds of law, it might be 20 years ago in law school, then I actually knew what that was about.
Yeah, but at the same time, you've got colleagues whom you trust,
yes,
that you can bring in and at least give them a good, solid referral that you feel confident
right. Well, last week, we interviewed Scott Shanos, and, it does workers' comp. And again, that's an ongoing relationship where Scott and I talked about a case this week, again, that he was able to answer real quick whether he could do anything for this client. And I thought it was great. And again, because he couldn't do anything for this client, but guess what? Scott, like I did, picked up the phone directly. I talked to my client directly and gave him the information he needed in 10 minutes rather than searching around or trying to get hold of a case manager or paralegals or secretaries. I'm not trying to be mean to support staff in the legal field, but you know what? There is no substitute for talking to an attorney directly about your claim. Just as simple as that.
Outstanding. Jim, I know you're incredibly busy. I want to appreciate and thank you for your time. And I hope the information that we discussed today is helpful. I know these things are serious for people who have been in a collision of some sort. And I know there's a lot going on, a lot of questions, a lot of confusion, sometimes a lot of pain involved. If you're in that situation, I'm gonna encourage you to pick up the phone and get a hold of my friend Jim Desmond, and he'll be happy to talk with you and get this thing taken care of. Jim, again, thanks for your time, buddy. Been a great episode, and we'll be out again in 2 weeks.
Sounds great.
Thank
you, Jim.
Bye-bye. That's it for this episode of the Kentucky Auto Accident Podcast. Jim Desmond will be back in 2 weeks to provide information you need to know related to car accidents and motorcycle wrecks in Kentucky. Until then, check out AttorneyDesmond.com. You can also follow him on Facebook at Attorney James Desmond. Drive safely, and please remember to buckle up.